Does anyone have a contract question or issue that they're dealing with they want to put out there this morning?
I have one. I have a potential buyer. Um, no, it's not the potential buyer. For the seller. They're in a trust and there's a co-trustee, but the co-trustee doesn't show up on the tax records, and apparently the trust is set up in a way that each of the two co-trustees can act independently. So do you have any opinion on whether both trustees would need to, both co-trustees would need to sign the documents?
Uh, just off the top, without seeing the document, it sounds like if they're both empowered to operate independently, yeah, you would want both signatures on anything you're writing for them, whether it be a listing or an offer.
Okay. Well, what I can do as we get further along, if we get further along, is to send all the trust to title and see what they
Yeah.
say. Yeah.
Yeah, for
Okay.
sure. Yeah.
Sounds good.
Yeah, we had the case I covered a couple weeks ago up in Timber Cove or somewhere, where the two parties owned the property as tenants in common, and there was a tenants in common agreement, and the tenants in common agreement called for if either party wanted to sell their interest, that the other party would have to approve. So one party was more, the property was listed for both parties, but one party's more interested in selling than the other and willing to reduce the price. So that party, we created a document that just gave them permission to go ahead and sell, and that the tenants in common agreement would be transferred to the new owner if the property sold. So, just you have to follow what the legal documents tell us. So, okay, so back in January when broker risk management went over the new laws that were effective passed in 2023, there was a new law which they referred to as the flipper statute. And it doesn't reference itself in the legal language at all as a flipper statute, but that's essentially what it's geared towards: those who are buying properties, fixing them up, and reselling them. And that particular law is effective July 1st, 2024. We have and that's for transactions that are either ratified on or after July 1st, 2024. So our one of our agents is looking at taking a listing for a property where the buyers bought it and remodeled it, and now they're going to sell it. So they would qualify as it applies to all transactions in residential 1 to 4 units. TDS categories, exemptions, and cancellation rights apply. So if you're exempt from the TDS, you would be exempt from this law, I take it. And it applies if a seller accepts an offer within 18 months from the date that the seller acquired title and did renovation to repair, and renovation to repairs were performed by a contractor who contracted with the seller. Or done by the seller himself. In this case, the seller is a contractor, so they did the work themselves, but it is within 18 months of the date they acquired it. So it requires a seller to disclose to the buyer, over above the normal disclosures, any room additions, structural modifications, repairs, or other alterations, a copy of any permits if obtained, or if the seller contracted with a third party, and was not provided with a copy of any permits, the seller with whom may inform the buyer that the permits may be obtained through the third party and provide their contact information. And these disclosures may alternatively be disclosed as a list as given by the contractor to the seller. And the C requirement is where the cost of labor and materials was $500 or greater, the seller will disclose the name of each contractor and the contact information of each contractor as provided to the seller. So there's just additional fine tuning about disclosures when you have a flipper property. So what we're doing in this case, because it's going to be listed here in the next 2 weeks, it'll be mid-June, that we're suggesting that this seller comply with this law, even though it's not effective till July 1st. So if you're dealing with a flipper property, make sure that that's part of your repertoire at this point, knowing about the flipper law. We had a question about dual agency, where an agent's going to be a single agent, dual agent, and in fact, just they got a call from a friend, I think maybe even a relative, that they owned a rental property and the tenant wanted to buy the property and they wanted to sell it, and could we do the paperwork? So we can do that, but we have kind of limits on how much we can discount the amount we charge. Typically, when we have a listing and then the seller has, the listing agent ends up with a buyer, let's say we started at a 5% commission, we would typically agree that to reduce it to maybe 4%. In this case, we really haven't marketed the property or anything like that. So I agreed that a 4% fee, would be suitable. It was in the price range of $600,000-700,000, I believe. So and the agent really wanted to discount that a little further because of this friend and because they didn't really do much work on it. And I said, well, that's fine. You can discount your commission however, you do whatever you see fit, and you give the seller a credit. The company would like to be paid its company dollar based on the 4%. So that's what we worked out. And the agent is okay with that, and we're okay with that. So if you do have that kind of thing where you're going to be charging a commission that would be, quote, less than our company standard, and remember, there's no industry standard, it's just our company standard, then do discuss it with Randy or me, and we'll get it figured out. Any questions on that? Okay, referral agreements. Well, let me come back to referral agreements because I'm going to refer to the form. So I'll skip on to listing we're going to take where the seller has received a notice of a default from the lender on the property. In this case, there's a sale date set, so they have a notice of sale, but the triggering event here is that they have a notice of default on the property. So when you take a listing that has a notice of default filed, that fact should be disclosed to purchasers. I don't believe it has to be disclosed necessarily at the outset, in the sense of putting it in the private remarks. But certainly once you are in an offer stage and someone submitted an offer, at that point, the seller through their agent, through us, should be notifying that buyer that there is a notice of default on the property, And that they should be aware of that. If the seller occupies the property and if it's single family 1 to 4, and if the buyer is an investor, then a whole nother procedure goes into play. And that's called a notice of default RPA. So it's a whole different purchase agreement. And I'll share this here. When you pull this up, and it says in large letters here, for use when an investor buyer offers to purchase an owner-occupied residential dwelling against which a notice of default has been recorded. So it's pretty clear when it's used, and it's got all the other perfunctory forms attached to it.
Just checking in, I have, or you all have, one of your guys coming out and taking a look at,
See if we can get
45.
Dan to mute.
Yes, just wondering.
Okay, there we go. Sorry. So it has all the other forms attached to it, and it has the grid, and everything else looks pretty much the same till you get down here to a section called seller right to cancel. And that's under a paragraph here called agreement subject to civil code. So the civil code calls for the investor buyer that the purchase is subject to civil code 1695. And if those codes are violated, there could be a civil penalty. And so the buyer needs to follow these codes. And what it does is it gives the seller cancellation right under here under B, and it says seller may cancel this agreement until midnight of the 5th business day following the day on which the seller signs this agreement. So there's a automatic 5-day, I don't know what you would call it, cooling period or review period in which the seller could cancel. Or until 8 a.m. on the day scheduled for the sale of the property pursuant to a power of sale obtained in a deed of trust, whichever occurs first. So it basically is giving the seller 5 days, assuming you've got a notice of default and you don't have a notice of sale yet, then that 5 days is certainly going to precede the day of sale. So under the deed of trust. So yeah, so it basically is giving them a 5-day cooling period or consideration period. And then there's these forms attached here, which are interesting. Notice of cancellation of notice default purchase agreement. And it says, you may cancel this contract for the sale of your house without any penalty or obligation at any time before. And we would enter that date in there, 5 days. And to cancel this transaction, person deliver a signed and dated copy of this cancellation notice or send a telegram. That's interesting. Name of purchaser at and the purchaser address and not later than, and the date again. And I hereby cancel this transaction. So that covers the seller's rights under that civil code that are different from normal. So any questions on that? All right. Let's then just go look
Gary,
at.
there's a question in the chat.
Oh, okay. What does it say?
For NOD, can you disclose after escrow or do you have to do so up front? If up front, possibly buyers may use this as an advantage in their offer.
Our attorney said it needs to be disclosed to all buyers, and that would be at the time they're writing a contract on it. So Yeah, it may trigger a sale, or what would you call it, advantage for the buyer, you know, knowing that the seller's in notice of default, but it's also a notice that has to be conveyed to the buyer. So it's just a reality that the seller has to deal with. Does that answer the question? Okay. So referral agreements, we've had I've always encouraged referrals. I think getting a referral is a good thing. You get 25% of the fee for doing 2% of the work. So do as many as you can. And we have referrals that are out of town and in town, and to agents within our own firm, sometimes within our own office. And you know, for various reasons. But so we use this form, the RFA, the referral fee agreement. And the referring broker is the one who's sending out the referral. So it is the broker, the agent, addresses, and the recipient broker is the one receiving the referral. And the principal is the party who's being referred. And then the agreement, whatever you agree to, that the referring broker shall receive. You know, it's typical, maybe it's 25% of the total gross commission. Though it's not, it's negotiable, could be higher, could be lower. Or a flat fee. And in the event the specified blow occurs no later than 12 months, so this is a 12-month agreement. And then you have these various things that they enter in,
Leave it alone.
or have entered into a,
What?
whoops.
I didn't hear you.
Okay, we'll go back to mute here if we can. Well, yeah, so there's these various categories that you're referring to buyer, or you're referring to seller, you're referring to a tenant or landlord, and so forth. So, and then the broker signs this on behalf of the firm, and you're ready to roll. We provide this to our commissions person, and they keep a record of it so that when the referral comes in, the dollar amount, we know who it's for. We check our records and see who it's for, and we send it along. Your portion of the referral. Any questions on that? Okay.
Wait, you hadn't, sorry, you had another question in the chat. It's asking what if buyer is owner occupant? Maybe for the disclosure question.
Well, they would still need to disclose that they're that the property is being sold, and that there's a notice of default filed on it. So, yeah. Sorry, it's just going to have to be disclosed. You know, and very often a notice of default would have wouldn't be because the seller is distressed per se. They may have a fair amount of equity in the property and still go subject to this the notice of default. But if that's where they are, they're probably going to want a sale, and you know, have to deal with the buyers that want to buy it. Question came up about just sold cards. So one of our agents represented a buyer in the sale of a property. So as we practice, yeah, you know, the company provides, I forget how many just sold cards that can be mailed out around to whatever party the agent wants to. Usually it's a geographical farm surrounding the property. And you get a list from the title company or something. And it says, you know, just sold, and then we recently participated in the sale up. And it's worded such that it could be for when we're representing a seller or when we're representing a buyer. Well, we got a call from the listing agent because they happened to get a card. You know, they live in the area. And they were upset. And they said, well, you didn't sell the property. And they, you know, we said, well, actually we did. You know, we represented the buyer, which is accurate. But they were upset that our agent sent out a just sold card. And I said, well, you know, let them be upset. It's what you're doing doesn't violate any code of ethics or anything like that. It's a practice that's been done for years and is all suitable. So send out those just sold cards, whether you're representing the buyer or the seller, because we participate in the cost of that. We talked about previously the RBC, broker representative form. As you start to use those, I think the new forms released, I was told, which comes out in June, will just have agent's initials on the pages, but right now that form calls for buyer's initials. I mean, the broker's initials. Well, I don't want to initial all these. So our attorneys have said, no, the agent is authorized to, we can authorize the agent to initial the BRBC on behalf of the broker, just like you do with the listing agreement, I believe it is, that asked for the broker's signature, but it's our practice that the agent sign on behalf of the broker. So if you're doing the BRBC, just go ahead and initial it on behalf of the broker. And then remember, we have to keep copies of all those BRBCs because they're legal contracts. So you send them over to buyer rep agreements at winecountrygroup.com. That's the website or the email site. Buyer rep, REP agreements at winecountrygroup.com. So send all your BRBCs there and we'll keep them for DRE purposes. Any question about that? Okay. We have a situation where we're representing a seller and the title company called for a payoff statement from the lender, and the seller and our agent both are disputing the amount of the payoff. It was originally an $80,000 HELOC that is 20 years old. And the husband of the couple, you know, always paid it and he maintained it. But then he died and the payments kept getting made, but for somehow the HELOC had a balloon payment after 20 years. And so it came up about a year ago or 2 years ago. And now the lender is pursuing collection through a notice of default and sale. Well, the surviving spouse still lives there, wants to keep the property, so is having to arrange for her daughter to buy it separately to make that work. So but the payoff came in and it was $176,000 without a breakdown, really. There was some past due interest, but most of it was principal, and you know, we're having a hard time figuring out how it jumped from 80,000 to 176,000. It wasn't a reverse mortgage or anything like that. So anyway, we went to legal, and because we thought the entities were out of the lender was a credit union out of Chicago, and the collection agency was a group out of San Diego, and it was all kind of foreign. It wasn't your normal, you know, Wells Fargo Bank or Bank of America, you know, payoff. And there was no detail in it. So we asked the representative. We got a hold of a representative. We asked them for more detail, and they said, well, we can't get you more detail. It's going to take too long. There's 30 years of transactions here, and we don't have the records, which is not a very good answer, but that's what they said. And so I ran it by legal, and just to see if they had heard of either of these organizations, and they were bad actors. Well, Shannon had not heard of them, and as I suspected, we cannot, our attorneys cannot represent the seller in sorting this out. And the seller's gonna, if they want to have an attorney challenge the payoff, they're gonna have to hire an attorney. So we sent along a few names for the seller to consider hiring to get to the bottom of the payoff. And the reason our attorneys can't represent our clients is that we pay our attorneys to represent us. And so they'll help us with contract documents and clauses and things like that further our transactions. But if it came down to a dispute between our client and ourselves, they would be our attorney and not the client's attorney. So as you know, attorneys can't represent two parties in the same transaction. So they have to decline representing the client in this case. Now, once in a while, where we aren't involved in the transaction, our attorney might take on a client that we refer to them, but that's a whole different matter. It's just a referral. It's not a transaction in which we're involved. So any questions about that? Okay. Those of you who are members of Norbar, which I think most of you are on this call, we got an advisory this morning about the Board of Supervisors voting on some tenant landlord statutes that are going to be drafted and put into law. And so this comes under the category of local tenant landlord ordinances. And it's important for us to not try to interpret them. This document that Norbar sent, actually in the document itself, had listed about 6 different resources where parties could go to get more information. Well, we aren't going to evaluate 6 different resources around tenant-landlord relationships. It's our first and only step really is to counsel our client if they're a landlord and they have a question about how to proceed with a notice to a tenant to vacate or those such things, that they work with a qualified California real estate attorney who specializes in landlord-tenant law. And again, we have people we can refer our clients to, but we can't interpret the tenant-landlord law for them. It's beyond our scope. Any questions on that? It's a complicated business, to say the least. Okay, then the last thing I have is a reminder about the forms release webinar on Monday. Broker Risk Management is doing their monthly webinar, and they will be highlighting all of the new forms. I think there were 61 either new or revised forms. The majority of them are revised forms. So I sent out the link in this morning's email. I will send it out one more time when the recording is done. I send out the recording, but make sure you register in advance. No feedback here. That you register in advance for these webinars, because that's how you get the link to join them. All right. All right, well, that's covered my menu for today, my agenda. Anyone have any other questions that we didn't address? 6/3, yeah, June 3rd, a week from Monday. Is that a week? Yeah, that's right. I'm sorry. It's a week from Monday, not this coming Monday. Thank you, Curtis. I hadn't, I thought June was right around the corner, but it's 2 weeks out. Great. And while I got Kendra on the line here, she signed up 2 contracts yesterday, so congratulations to Kendra. Well done. And Patty signed up a new $4 million listing, so congratulations to Patty. Business is picking up. All righty. Enjoy your day and weekend, and we'll talk to you soon. Thanks very much. Bye.
Thank you.
Bye.